presented below. It also, with respect to the second element, applies to not allowing plaintiffs to allow at the last minute amend their pleadings to the detriment and prejudice of the opposing party and without proper notice and due process. And in the third respect, it applies to allowing a litigant, and especially a pro se litigant, the understanding of what the issues are procedurally that they are encountering with respect to admission of evidence, allowing them the ability to try to overcome those and present their evidence. And as we see in this instance, that wasn't done, and the appellant, Brittany White, was effectively disallowed her ability to make a counterclaim despite presenting evidence that almost facially should have been allowed as a business record.
Well, let's start there. Let's start, from the last point that you made. So your contention is that the trial court should have given the pro se appellant some advice on how to lay a proper foundation. So is that your position?
No, Your Honor, not exactly. I think obviously we're well aware that the court has to be careful not to give legal advice or to appear impartial or rather partial to any one particular party. I think what we were looking for and what we would ask in the appeal is that the trial court should have at least told the pro se litigant what the bases that were being elicited for purposes of the evidence had not been met and what portions of the foundational requirement that Ms. White still had to meet and overcome.
So just make sure I'm clear. So the appellee, objected to the admission of the evidence, correct?
Yes.
And made a hearsay objection multiple times, correct?
Yes, correct.
All right, so it's your position that the trial court should have stated the precise basis for the objection for this pro se appellant?
No, as I look at the record, Your Honor, I believe it's clear that the majority of the issue was that it was a foundation issue with respect to establishment of a business record. The documents themselves were almost facially business records. They were payroll records. The record indicates that there were also contracts between Fidus Roofing and its customers as well, and that were the basis for the commissions. So the issue was that there was a hearsay objection. And despite multiple attempts to lay a foundation, the trial court determined that the foundation had not been met, but it was not clear, even on a reading of the record, exactly what the infirmity was with respect to the foundation. Our argument would be that the trial court, dealing with a pro se litigant, not having the same understanding of exactly what the foundational requirements would have been, should have explained what the basis that the court was determining that the foundation had not been met. And
I think I understand your argument, but what procedural rule or what authority would require the trial court to do exactly what you are describing here?
I don't think, Your Honor, that there is a law or rule itself that in and of itself says trial court must expressly make clear its rulings. However, I think it's fundamental in the access to courts argument to say that the trial court should ensure access to court by making sure that its rulings are clear enough that a person who doesn't have the benefit of an attorney understands how they may overcome without overstepping into the boundary of providing legal advice or providing some sort of special help, just helping the pro se litigant understand what portion of the foundation that the court believes has not yet been met, and then it's up to the litigant at that point to make sure that they overcome that issue. And the court doesn't have to tell the person exactly how to go about overcoming that, but if the court at least lets the person know what they have not yet met. For instance, if there was we don't know whether it was an authenticity issue or whether there was some issue with respect to the way the documents had been kept or maintained. It's just not clear from the record exactly what the trial court found to be infirmed with respect to the foundation. That should have been made clear so that the litigant could have a meaningful access. Essentially, by not explaining the foundational issue, it amounted to an involuntary dismissal of the entire claim.
Well, let's move on to the second point. You've argued that the trial court abused its discretion in allowing the appellee to amend its pleadings to include a claim for embezzlement. My understanding of the record is that issue was raised before the trial. Is that correct?
In part, Your Honor. There was an initial, approximately at about 6 weeks prior to the trial, there had been a filing that referenced just the word embezzlement. That there had been, the word embezzlement had appeared in a filing in a motion in limine, actually by the appellee. However, there was no indication made at that time that there was any intent to introduce that as an evidence, as an issue rather in the case, or that it was going to be sought to be a claim that was going to be made. In fact,
And before you move on, did the appellant in any way respond to that motion and reference embezzlement at all in its response?
yes, Your Honor, there was an objection filed, and what makes clear from the record is that the appellant at that time understood that the reference to embezzlement was not raising an issue for trial, but as the appellant saw, was improperly trying to reference a collateral criminal action and basically trying to impugn her character by referencing embezzlement from that action.
But certainly by the time you get to trial, it's clear that the embezzlement claim is at issue. Was there any objection at trial to that claim?
Numerous objections, Your Honor, both leading up to, and in fact, just to take a step back, the issue was heard by the court on the objection to the reference to embezzlement on June 10th. And in fact, there was a pretrial filing by the appellee that indicated the nature of the complaint to be raised, and there were no issues raised under the section that included potential amendments to the pleadings. There was no amendment listed to include embezzlement. The reference to embezzlement was, at that time, it was limited to basically, as the appellant believed, was a reference to her character and trying to implicate the criminal action. But at trial, there were objections raised to that issue, and in fact, in the trial itself, there was only in the opening statement, there were, I believe, 3 references of the word embezzlement in opening statements, but then throughout the entirety of the presentation of appellee's case in chief, no reference to embezzlement in the record. There were no allegations pertaining to that. No causes of action were alleged in the presentation of the case in chief, and the embezzlement statute was not mentioned until at the close of evidence, the appellee sought to conform its pleadings to the record, the evidence presented, and at that time alleged that the issue of embezzlement had been tried by consent. When, in fact, as we mentioned on the record, there were no, other than the initial opening argument of counsel, which was, as the court well knows, not evidence. There was no presentation of evidence on the issue of embezzlement throughout until, as we mentioned, at the close of evidence, when there was a motion to conform to the evidence presented. As I mentioned, it was supposedly at that time based on consent. I think it would be a stretch to construe that the record indicates that there was any consent to the trying of that, especially because there was a pretrial objection that the order from the trial court actually indicated that that objection would be taken up at trial, and that any ruling on it would be deferred until that time.
Okay. Well, let's move to your first issue, which is an objection to the final judgment and numerous legal findings by the trial court. But kind of central to the theme of several of your arguments is that the trial court's finding that damages were difficult to ascertain amounted to a finding of no damages, and that without a damage finding, there could not be an award of injunctive relief. What's your authority under 688 or 542 or any of the statutes at issue that a trial court must award actual damages in order to award injunctive relief?
Yes, Your
or
Honor.
grant?
With respect specifically to Chapter 688, we don't believe that statute was applicable to the final judgment as it was awarded, as the final judgment made only a passing reference to Chapter 688 in a paragraph that referenced other types of avenues for civil relief that were not applicable to this case as well. There was no finding of the specific willful and wanton intent that would have been required under 688. There was no, under the paragraphs that awarded the injunctive relief, there was no reference to 688. there's no reference, as I mentioned, other than that one passing reference in a section that references other statutes that didn't apply to the final judgment and that appellee agrees were not part of the case. Other than that passing reference, there was no reference to 688.
Well, let's maybe go to the statute and look at section 688.003, which is the injunctive relief provision, and it clearly says actual or threatened misappropriation may be enjoined. The trial court found that there was actual misappropriation, did it not?
Well, the trial court, the final judgment is in some ways inconsistent internally. It was, as we note, it was drafted by the appellee and provided to the trial court. The trial court made some changes and amendments. The trial court did, yes, Your Honor, in one part find that there was misappropriation, but then also found that there had been nothing done with any of that information, that there was not any evidence that that information had been given to anyone, used improperly.
But 688 doesn't require the use of the trade secret information. There is a presumed irreparable harm when a trade secret is misappropriated. And in my reading of the final judgment, it's very clear that the trial court found that trade secret information from the appellee was misappropriated by appellant.
Yes, Your Honor. We agree that there were findings made to that effect.
All right, so let's go back to the statute. If there's appropriation, actual appropriation found, it may be enjoined. So what else was the trial court to do under the injunctive relief provision?
To answer Your Honor's question, the issue was, from our standpoint, there was a presumption of harm. And based on the finding that there were no damages awarded by the trial court, we found and would argue that the trial court found that despite the presumption of harm, there was no actual harm, and there was no actual harm found by the trial court. The injunction was issued under the statute pertaining to unlawful trade, and instead was referencing the appellant's impermissible competition with the defendant.
Counsel, did the trial court find that the plaintiff specifically failed to prove any damages?
There were no damages awarded, Your Honor. There were references to harm in the findings, but in the net, there were no actual monetary damages awarded.
I understand, but did the trial court so find that the plaintiff failed to prove any damages?
The trial
or
court,
the amount of damages?
Yes, Your Honor. The trial court, Your Honor, determined that the damages that were adduced in terms of evidence at trial were not sufficient in terms of their specificity and were of the incorrect type. So I think that would imply that there was evidence of damage, but that there was a finding that no monetary award of damages, and thus we're left with the finding that there were no damages.
Thank you.
Thank you, Your Honor.
Please, the court. My name is Christopher Cobb, and from Jacksonville, and I represent Fidus Roofing and Construction in this case. We ask that the court affirm the final judgment granting injunctive relief for Fidus. I'd like to take with the panel's permission, take the issues as they were inquired about. First being that the requirement of the trial judge below to be as lenient in evidentiary rulings and explain to the defendant the basis for the objection and how they can overcome it. You know, appellant has said that there's no law or rule requiring that. In this case, the issue that was framed is that the trial court failed to allow her to correct deficiencies. The trial court did not refuse to allow the appellant to do anything in this case. In fact, the record is replete with the trial court explaining procedural rules to the appellant, granting her great leeway in her arguments and what evidence she tried to put on. The fact that she can't substantiate the foundation for the documentary evidence that was objected to, the trial court is not required to say, well, if you do 1, 2, and 3, your evidence will come in. In fact, I believe the trial court should be commended on its treatment of the appellant throughout this entire case. The appellant tried to get her documentary evidence in through the business record exception rule, which is 908036, and there are certain requirements that she has to meet. During her examination of witnesses, she was not able to meet those requirements under the statute. And the statute says that it is an exception to the business, or the exception to the hearsay rule, these business records. But if they lack trustworthiness, then the court can keep them out. And I think an important distinction here needs to be made is these records that the appellant tried to get into evidence were not business records. She did not get through the 4 criteria under the statute to meet the exception. But even so, if you look at the record, the testimony of one of the witnesses was Mr. Suppley. The example is at 3640. The appellant tried to get in 16 pages of documents that purported to be FIDA's records, but they were not. They were commission request forms, and they were altered documents, and it was a compilation. And so not only could she get through the actual criteria to meet the business exception rule, but the witness testified under oath that this looks like a contract of mine, but it's not signed, so I don't know what it is I'm looking at here. And the compilation put together were self-serving documents that were not authenticated. They were not exceptions to the hearsay rule. They were self-serving compilations, and that is the tone and tenor of these objections that the appellant continuously tried to get records in. The reference to payroll records was one that the document was altered. It had a total at the bottom, and the court let it out. But the court took testimony as to what the damages were. In one instance, there was a document that the appellant created showing what figures that she thought, and it was taken. An objection was issued, and the court sustained the objection based on improper summary, because there was no backup to it. There was no notice of intent to use the summary. There was no document substantiating the summary, and so the court properly kept those documents out. You know, this is not an instance where we're trying to put the appellant through the paces. We stipulated to multiple exhibits coming in, but these self-serving compilations, these records that had been altered, these spreadsheets that had been dragged down to show multiple commission layers beyond what was allowed in the testimony, those were altered documents, and the court properly left them out. All of the records for commissions were testified to on direct examination of the appellee's corporate representative. And so the court properly kept those records out. They were not authenticated, and there is no requirement that the judge tell the appellant how to put on her case.
Well, and let's move to the second issue, the amendment of the pleadings to conform to the evidence. Let's assume that there was short notice sometime before trial that this embezzlement claim came in. And let's assume that there was some form of objection made to that claim. Even with some shortened period of time for the plaintiff to prepare to defend against that embezzlement claim, how does that amount to an abuse of discretion? Or how could that amount to an abuse of discretion? When would it amount to an abuse of discretion under these facts?
Well, under these facts, there was no abuse of discretion for the trial court to grant this motion for leave to conform with the evidence. The appellant has not shown any prejudice here. And
when was the appellant first placed on notice of the plaintiff's embezzlement claim in this case?
the embezzlement claim actually appears as a misappropriation claim in the complaint. This case is and has always been about theft of trade secrets. The first time we used the term embezzlement by misappropriation was in a motion in limine related to other extraneous issues that the appellants were trying to get into evidence. Thereafter, they filed their own motion in limine seeking to exclude the term embezzlement from the entire case. After that, and this case took 9 months to try, from filing the complaint to a 4-day bench trial during a pandemic. I think it was one of the first Zoom trials that Judge Wilkinson had conducted in Duval County. And so the appellant wasn't deposed until after the reference of embezzlement. And so during her deposition, we asked her about embezzlement. There is a pretrial stipulation that was filed where we referenced 4 times the issues to be tried by embezzlement. We filed a pretrial brief where we listed the 812 as a statute for the embezzlement. We referenced three times in opening statement that the evidence will show that she embezzled these records. And then we don't have to say the word embezzlement during the trial. We put on evidence that substantiates that conduct, and that is what we did, and that's what the court found. During cross-examination, appellant cross-examined my client as to embezzlement. She argued at trial as to embezzlement. She cross-examined witness Matt Brain, and she made and there was a request for judicial notice that we filed seeking the court to obtain, give judicial notice for that statute. So not only did she raise the issue pretrial, she was deposed on it. She knew that the evidence that was going to be presented raised embezzlement. It was listed as an issue to be tried in the pretrial statement. She cross-examined witnesses based on embezzlement. And finally, the final sort of point to that would be we closed the case. I think we mentioned embezzlement at least 20 times in our closing argument, that the evidence established at trial proved that she embezzled by misappropriation. And the appellant got to provide her version of the proposed findings of fact and conclusions of law. And in her version, in Section M, she references that she did not embezzle the
So
record.
understanding, if we agree that there was no prejudice and we agree with the trial court on that point, this claim fails, correct?
That would be our contention, Your
All
Honor, yes.
right, so if we could look to the multiple issues raised under Issue 1, and again, most of them seem to revolve around the fact that the trial court chose not to award damages, but did grant injunctive relief on several grounds. You know, reading the final judgment, in paragraph 16 of the final judgment says the plaintiff has suffered and will continue to suffer irreparable damage, and the threat of future damage to plaintiff is real and immediate, and then granted the permanent injunctive relief. Was it necessary for the trial court to say under which statute it was granting that injunctive relief?
No, Your Honor, I think there's multiple avenues. We had a standalone claim for injunctive relief. In our uniform trade secret claim in the complaint, we actually referenced 688-003, which says that we're entitled to injunctive relief under that statute. Of course, the statute provides the remedy, and it allows the court to fashion affirmative relief to protect those trade secrets, which the court did say in paragraph 11 of the final judgment that it conclusively or convincingly plaintiff or appellee had established that the value of these trade secrets to our clients. So there was convincing evidence.
And the appellee was also entitled to injunctive relief under 542 in the contract, correct?
At 542 and under the terms of the contract, which allowed for, yes. Your
And
Honor.
again, is there any requirement under the law that the trial court needed to specify under which provision that had been pleaded in the complaint it was granting that injunctive relief?
I think, I can't find, I don't know. The answer to that is no. And I think given the tone and tenor of the final judgment, it's absolutely clear that the appellee established that it was entitled to the relief it was requesting, which was injunctive relief from the get-go. I mean, if you look at the title of the complaint in this case, it is Complaint for Injunctive Relief and Other Relief. And so the notion that there was that the court found that there's no damages to be awarded, that doesn't mean that there wasn't evidence of damages. But these types of cases, damages are sort of a secondary aspect. The primary aspect of it, and there's even cases under this that because of the difficulty of proving those damages, injunctive relief is the primary remedy that is awarded.
All right. Well, and with that, one of the other arguments as made in several places in the initial brief is that the fact that there were no damages awarded means that the claims under 688 had to fail. And again, under 688-003, are you aware of any authority that would support the notion that a trial court must award damages in order to also grant injunctive relief?
Under 688-003, no, Your Honor. I think the court may grant monetary relief, but injunctive relief is the primary mechanism. I'm not aware of any case that says because I granted the injunctive relief you were seeking, but you couldn't prove any damages as to that conduct, that the whole case should be thrown out and dismissed. I'm not aware of any case.
Do you think the same is true under 542's non-compete provisions? That if a trial court denies an award of damages under 542 but grants injunctive relief, that is supportable under the statute.
I believe it is, Your Honor, because again, the primary remedy is the enforcement of the restrictive covenant, which is either the covenant not to compete, or in the other statute, the protection of the trade secrets. Judge Lewis, you look like you were going to ask a question.
I'm good, thank you.
So based on those arguments in the briefs and based on these comments, Your Honors, we would request that absent any further questions from the panel, would request that the final judgment be affirmed. Thank you.
Thank you, counsel.
Briefly on rebuttal, Your Honor. I think it's important to keep in mind just a couple of points of clarification. With regard to the purported stipulation referenced by the appellee, actually there were two stipulations, quote-unquote stipulations, filed pre-trial. They were competing. Neither were truly stipulations. They were filed by each party. In the stipulation filed by the appellee, there was, as we mentioned, under the provision regarding potential amendments to the pleadings, there were none listed. In fact, it stated none at that time. Therefore, I think the appellant could not have been on notice that there was a proposed amendment to the pleadings to include any claim of embezzlement at that time. To answer the point raised by Your Honor with respect to the requirement that the court cite Chapter 688 in awarding the injunctive relief, no, there is no requirement. We would agree. However, the trial court did go out of its way to specify that it was referring to Chapter 542 and the contract as the basis for that injunctive relief. So the trial court has determined that those two were the avenues that it chose to award the injunctive relief. May I, 10 seconds?
Yes, I'll give you 30 seconds to wrap up.
Thank you, Your Honor. The final point that we would make is that the major question is whether, for purposes of injunctive relief, whether there is certainly a presumption of harm and ongoing irreparable harm. But that presumption was never supported, and therefore there were no damages issued. That is the legal issue that we would raise.
So, for the sake of argument that we agree with you as to that point, what relief are you seeking from this court?
With respect to if there's a finding that the plaintiff, the appellee, failed to prove its damages, that's, as we cited in the case law in our brief, that's a one bite at the apple issue with respect to proving the damages. So if plaintiff failed to prove harm, which it's clear that the record indicates that there was no use of those, no actual competition, no actual harm to the plaintiff. If the appellee failed to adduce that evidence at trial, then those claims would be dismissed on appeal, and that's what we would request.
Okay. Thank you, counsel. Thank you both. This court will adjourn.
All rise.